Donald Trump's counterclaim is dismissed. This comes from Judge Kaplan. You may remember him from the E. Jean Carroll trial. E. Jean Carroll sued Donald Trump, and she lost the big one, the big charge. You remember this verdict form. She alleged that Trump did the old hibbity-dibbity in that dressing room at Bergdorf's, but the jury didn't believe her because she's weird and probably a liar, at least as to that charge. Here's what they said. As to count 1, did Trump do the R on Miss Carroll? Answer, no. Jurors said no. No R. Total exoneration. Incredible. Did Miss Trump abuse Miss Carroll? They said yes on that one. That's the old DJ diddle. And so we have a little bit of a conflict here. That's strange. E. Jean Carroll said that Trump did the hibbity-dibbity, but they said he only did the DJ diddle. So is she a liar or is she not a liar? Because on the first count, she's a liar. After this verdict was handed down, E. Jean Carroll and her lawyer, Roberta Kaplan, no relation to the judge, they went out on the media and they were saying all sorts of stuff. And one thing that E. Jean Carroll said was that Trump did do the hibbity on her. That's the R word. And we say, no, that's not true. He was exonerated on that charge. And so Trump filed a counterclaim. Trump sued E. Jean Carroll back and said, hold on a minute here. If you're saying that I defamed you and that I did this thing and I didn't do the thing and you're saying I did, then you're defaming me, the old switcheroo. And so that sounded like a pretty good claim, but the judge has reviewed it. 24-page filing issued in the case of E. Jean Carroll against Donald Trump. Here's the order. Granting E. Jean Carroll's motion to dismiss Trump's counterclaim and defenses. So Trump countersues. E. Jean Carroll files a motion to dismiss the counter lawsuit. She wins. And there's Alina Abba doing excellent legal work as usual. The judge writes, all right, this is Judge Kaplan. And remember from Judge Kaplan, he absolutely hates Trump. We listened to him this whole trial, twist this into some sort of perverted outcome. But he responds, he says, all right, well, this is a defamation case against Donald Trump brought by E. Jean for certain statements that Trump made in 2019 while he was president. E. Jean said that he did the hibbity in the mid-90s. In a second case, she sued him for defamation under the Adult Survivors Act, which allowed an extension under the statute of limitations to prosecute Trump. This is also known as the Prosecute Trump Law that they basically passed so that she could bring this claim. Carroll was tried in this court. Mrs. Carroll testified that Trump assaulted her in a dressing room in what most likely was spring 1996. Among other things, doing the hibbity with doing the DJ diddle with his fingers. And she said that he also did the hibbity with his other thing. The essence of her account was corroborated by 2 outcry witnesses in whom she had confided shortly and 6 other fact witnesses. And all these people were like bizarre witnesses who knew nothing. Mr. Trump relied exclusively on trying to discredit Miss Carroll. He did not testify. He did not attend. He did not present any evidence. The jury's unanimous verdict was almost entirely in favor of Miss Carroll. It found that Trump did abuse her, which is defined as contact by forcible compulsion, and it's a felony punishable by imprisonment, not in this case, it wasn't charged as a crime at all, and registration as an offender. But this is not the relevant law here. He was never charged with a crime. This was a civil case. It determined also that Mr. Trump defamed Miss Carroll in 2022. It awarded Carroll $2 million in damages for her battery claim and $2.9 billion for the defamation claim. And remember how hard we were laughing about this? The jury gave her $3 million for saying something that is untrue about her, but only gave her $2 million for the actual DJ diddles. So she got actually the lie or whatever was worth more damage than the actual DJing, you know? And I go, what the? All right. So it's just bizarre. So the only issue on which the jury did not find, this is the judge writing, in Miss Carroll's favor was whether she proved that Trump did the hibbity within the narrow technical meaning of the term of New York law. The jury was instructed that it could find that Trump hibbitied her if he forcibly penetrated her with his member. It could not find that he hibbitied her if it determined that Trump forcibly penetrated with his fingers, which is commonly considered, the judge says, the hibbity in other contexts, because the New York law definition is limited to the member. As the court explained in a recent decision, denying Mr. Trump's motion for a new trial was based on the verdict as a whole. The jury's finding that Trump abused her implicitly determined that he forcibly penetrated her digitally, and as the term is commonly used and understood outside the context of New York law. So he's just making it up. You know, New York law doesn't say it. New York law says it has to have the actual member in there with your member down there. But it's commonly used and understood outside. So the day after the jury's verdict, Miss Carroll and her counsel gave interviews with the media where they discussed the trial and Miss Carroll's reaction to the verdict. In the answer, Mr. Trump asserted for the first time a defamation counterclaim. He said that Miss Carroll, in an interview with CNN, disregarded the jury's findings, that Trump did not prohibit her, stating that when she heard the jury's response was no to the question, she responded, "Oh, yes, he did. Oh, yes, he did." They said, "Hey, E. Jean, what did you think when the jury came back and said you're a liar and Trump is not responsible for the hibity?" She said, "Oh, yes, he did. Oh, yes, he did," and stated at the conclusion of the trial, "Trump did it, and you know it." She said to Mr. Trump's counsel, "Mr. Trump did it, and you know it." So the matter is now before the court. Miss Carroll filed a motion to dismiss Trump's counterclaim, and the judge is laying out some facts for us. He gives us some different definitions under New York penal law. The court instructed the jury according to the jury rules, and they're rehashing the jury rules. The instructions and the jury instructions made clear if the jury found that Trump used his fingers but not his member, then they have to say no. But digitally, then answers yes on the abuse question. Miss Carroll's statements after the verdict. Here's the exchange. On May 10th, the day after the jury's verdict, Miss Carroll and her lawyer showed up on CNN. During the interview, Miss Carroll made the following statements. Reporter says what about when that first finding was found? This jury found that Mr. Trump did not hibity you. What about that moment? E. Jean says, "Can you explain the legal?" And the reporter says, "Sure, yeah, I want you to explain the legal, but I just wonder, E. Jean, you know, what went through your head?" Like, I don't want to hear the legal answer. What went through your head when you heard that? "Well, I just immediately say in my own head, 'Oh, yes, he did. Oh, yes, he did.' See, that's my response." There in the courtroom was an encounter and an exchange between you and the president's lawyer, Joe Tacopina. He came up, you shook hands, I believe. What did he say? E. Jean said, "Well, Joe Tacopina is very likable. He's sort of like an 18th century strutting peacock," whatever that means. "And people like him. So when he sticks out his hand, first he congratulated Robbie, and then he congratulated people on the team. And as I put my hand forward, I said, 'He did it, and you know it.' Then we shook hands, and I passed on." So Trump alleges that she made falsehoods and defamatory statements by saying that, "Oh, yes, he did. Oh, yes, he did." Say, "No, they didn't. The jury found I didn't." He contends that she made those statements with reckless disregard for their truth and falsity. And so the judge sets the legal standard, establishes some rules, and says Miss Carroll argues that there's no claim. And she says that Trump has failed to legally state a sufficient claim because her statements were at least substantially true. Close enough, because Mr. Trump has not adequately pled actual malice, that she didn't say it maliciously. And so in view of the following analysis, there is no need to address the sufficiency of Trump's actual malice allegations. The judge continues, as Trump's claim is insufficient, it establishes against him the substantial truth of Miss Carroll's accusations. And he uses the word "are" in quotes. It goes from without quotes to with quotes. In any case, the finding says, as noted above and in a prior decision, the issue of whether Trump hibitied Miss Carroll within the meaning of the law was in this case for one and only one reason. In any case, the judge writes, Miss Carroll's statements were substantially true. So it's good enough. The digital finger is a digital hibity. So you can hibity somebody with your DJ diddles. He says it's conclusive with respect to this case. And as a result, the statements are, quote, substantially true. The finding that Trump digitally hibitied her is conclusive because it's necessary to support the judgment that was rendered in this case. It's the only remaining conclusion and it's the only truth. Mr. Trump digitally hibitied Miss Carroll. And so it's substantially true and therefore Trump's claims are dismissed. Foregoing reasons, Miss Carroll's motion to dismiss Trump's counterclaim for defamation is granted. Her motion to strike his affirmative defenses is granted. They're all denied and so ordered. Trump's counterclaim predictably dismissed by Judge Kaplan in the E. Jean Carroll case.